Hi, my name is Bob Pickle. Welcome to our program, Matt's Jeff Krueger Refuted. This is a rebuttal of Jeff's reasons for terminating the Matt membership of 5 Norman County townships, reasons he read at the hearing of January 5, 2023. Reasons Matt was required to give me an opportunity to rebut at that hearing, but which Matt refused to do. You can check out the video of the entire hearing at the link below. This video will be fast-paced, so as not to weary those who want something shorter. If you want to read more, simply pause this video wherever you'd like. Before we start, we're going to throw in 2 documents that were referred to in the video of the entire January 5 hearing. Gary Burdorf started the hearing by referring to a revised dues statement. Here is the original dues statement. As part of an attempt to bully into submission the NCAT directors, Matt sent the annual dues statement directly to Norman County's townships, which is a violation of Matt's own bylaws. Note here how Article 4, Section 2, requires that the dues statements be sent to the County Association of Townships, also called county units. Now note the highlighted parts of the dues statement that was sent out to Norman County townships. It's the same old form we receive every year, and clearly shows that Matt and NCAT dues were supposed to be sent to the Norman County unit. The only difference was that a label was placed over the mail to address. NCAT dues were supposed to be sent to Matt County instead of NCAT. Never heard of Minnesota having a Matt County? I scanned the back of the form and digitally adjusted it in order to make the print on the other side visible. You can clearly see that Matt County covered up my name, Bob Pickle. I just thought this was a bit tacky. The second document I want to show you is the agenda for the hearing. Here's the order for the townships to speak, which we were not informed about until the hearing began, which is why I objected. And here is where the agenda limited debate, thus forcing the agenda to need a 2/3 vote in order to pass. Here's where Article 5 of Matt's bylaws require Matt's meetings to follow Robert's Rules of Order. Some may argue that this bylaw requirement doesn't apply to meetings of the Matt board, but you have to understand. The reason democracy works is because the minority feel they've been heard, even if they lose the argument. If a simple majority can prevent the minority from being heard instead of a 2/3 vote, our democratic processes will not work so well. Here's a clipping from a 2004 issue of Matt's newspaper, which says that a 2/3 vote is required to limit debate. The problem we're facing is that those in control of Matt tell us we should follow the rules, but they only follow them when they feel like it. And with that, we begin our program, Matt's Jeff Krueger Refuted.
Let's see. Now we are at the reasons for termination. When we set this meeting, we did not expect these 5 townships to drag other townships into this matter. We set up the Zoom meeting as a convenience so those township officers did not need to travel to our office. This meeting is going to be much longer to the necessity of offering an explanation to you of why we're here. Is one more example of and reason that their values, these 5 individuals, are inconsistent with the Matt organization.
After receiving notice of the hearing and its rules on December 20, the NCAT board voted this response, sent on December 21st. One of the sections of the response consisted of objections. Note this objection. We asked for a public trial. This is America. America has public trials to ensure the appearance of impartial justice. And yet, Krueger asserts that our desire for a public trial was contrary to Matt's values. That assertion, along with everything else about this whole saga, raises the question of whether Matt has repudiated the American values of transparency, free speech, due process, rule of law, right to face one's accusers, and impartial judge and jury.
I feel all Norman County Township officers should be made aware of the problems created by Messrs. Pickle, Krueger, Werby, Manthe, and Lee for the Matt organization, its staff, and directors. Unfortunately, many of you do not know what happened over the last 3 years in our interactions and attempts to provide an NCAT board with services. We know you have received letters from Mr. Pickle that make outlandish claims and misrepresent the last several years' events, much of which you have read as fiction.
Fiction? Really? Matt's only attempt that I can recall at pointing out any inaccuracies has been in its September 23rd cease and desist letter concerning the NCAT resolution. We asked on December 21 for Matt to provide us a list of specific misstatements in NCAT's resolution as we were preparing for the January 5 hearing. Matt failed to provide us with even one misstatement, which indicates that Krueger knows I don't write fiction. Here's our request for specific misstatements on December 21st. And here's the rest of that request.
We are here because 5 men made statements that were untrue and harmful to Matt, its staff, and its directors. The NCAT board were informed of the problems and given a solution. They not only refused, they made further offensive statements and actions. Given this history, Matt has no interest in continuing any relationship with these 5 men. Membership in Matt is a privilege, not a right, and their behavior has made it impossible to continue to work with them. Our organization's bylaws provide that townships are the members of the organization, that officers of those townships are considered members. There's currently no way to remove an individual from membership in Matt without removing the township.
This is a very damaging admission by Krueger. If every town officer is a member of Matt, every town officer should have been given an opportunity to be heard before being expelled. This is what the law requires. Here's where Matt's bylaws say that every town officer of a member township is a voting member. Here's the list of minimum legal requirements before expelling a member. And here's the statute as found on the state's website with the part highlighted that says that members must be given an opportunity to be heard before being expelled.
We will look at options to correct that problem in the future, but we will no longer continue a business relationship with these 5 men. Now, they have claimed an unfairness to their fellow officers in their towns if their towns are removed from that membership.
Matt has admitted that the 5 town boards did nothing wrong, and thus it is unfair to expel them. Matt's articles of incorporation say that member eligibility and obligations are in the bylaws. The bylaws only require that members be town officers, be members of a county unit if one exists, and pay dues. Matt imposing other requirements such as not raising concerns and not calling for resignations went beyond its powers and was therefore wrong. Here's a few tidbits about corporations and common law. Matt has repeatedly told us that townships can only spend money on that which statutes permit them to. This is because corporations have only those powers granted them in their charter or by statute. Ultra vires is a Latin term meaning beyond the powers, and thus an act that goes beyond the powers is called an ultra vires act. Here's page 1 of Matt's Articles of Incorporation. Here's Article 5, Section 1, that says that members' eligibility and obligations are in the bylaws. Here's Article 3, Section 1 of Matt's bylaws, which mention 2 requirements for being a member of Matt. You must be a town officer, and you must be a member of a county unit if one exists. And here's Article 4, Section 2, that adds a 3rd requirement, the payment of dues. Besides expelling the 5 townships, there may be additional ways that Matt is engaging in ultra vires acts that it doesn't have the power to do. What are the remedies? At least 50 members can seek an injunction, or a single member or director can sue current or former officers and directors on behalf of Matt. The Attorney General could also bring a case against Matt for violating this chapter.
They're trying to stand behind 20 people who have not done anything wrong, only to protect themselves. They had a simple and effective means to prevent this expulsion from happening and to prevent their fellow officers from being removed as members. However, they refused.
Krueger here refers to his later demand that we revoke the resolution in its entirety and apologize. But we had already bent over backwards in our response to the cease and desist letter, offering to correct and apologize for any inaccuracies, no matter how trivial. And the NCAT resolution itself said the corrections were welcome. Here's our September 30 response to the cease and desist letter. Here are the various places in that letter where we proposed corrections, offered to make more corrections if Matt could provide evidence that what we said was a mistake, and offered to apologize. And here we point out a problem. We felt it was in Matt's best interest that we issue a single amended resolution rather than multiple ones. Otherwise, Matt might end up looking like it was harassing us. But we left it to Matt to tell us which it preferred. And that's why we did not issue the amended resolution right away. We were awaiting further instructions. Regarding apologies, we invited Matt to inform us which inaccuracies it felt we needed to apologize for. If we apologized for a trivial, immaterial point, Matt could end up looking like it was being petty. And thus it was in Matt's best interest that we not apologize for minutia. Here toward the end, we again say we'd be happy to make public our corrections. In the beginning of our letter, we even offered to get a website, such as mattvindicated.com, and put material on it that would clear Matt of the various allegations. And yet, Krueger says that we refused.